Hi and Assalamualaikum warahmatullahi wabarakatuh to our lecturer and fellow classmate. We are from group 5 and today we are going to present our article review for the subject LAD 4012 Client Counseling and Sulh. The title of our article is Compliance with Sulh Consent Order in the Selangor Syariah High Court. Without further ado, let us begin our presentation. Okay, before we start, let me introduce myself first. My name is Siti Nurain binti Mat Zaini. I'm matric number 1232396. Okay, now we're looking forward for the basic information of the article. This article is written by Muhammad Shazwan Zulkifli and Muhammad Nasra Muhammad, 2025. Examine compliance with Sulh Consent Order in the Selangor Syariah High Court. It highlights the factor affecting compliance, challenge of implementation, legal implication of breach, and recommendation to improve the effectiveness of Sulh in Islamic family law. Okay, next we move to the introduction. Sulh is an important alternative dispute resolution (ADR) mechanism in the Malaysian Sharia Court, particularly in resolving Islamic family dispute. This article focuses on the issue of compliance with Sulh Consent Order after they have been endorsed by the Selangor Syariah High Court, highlighting the challenge of non-compliance and emphasizing the need for effective implementation to ensure that the settlement agreement are successfully carried out.
Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Fatimah binti Muhammad Syafi'i. My matric number 1231623. Now I want to talk about the summary of the article, the concept and impact of Sulh. The implementation of Sulh mutual agreement in the Sharia Court serves as a proactive step to resolve cases without undergoing lengthy courtroom trial, effectively reducing the backlog of registered cases. Beyond being a mere dispute resolution tool, Sulh play a significant role in restoring community harmony and preserving the institutions of marriage by preventing unnecessary divorce. Selangor pioneered this comprehensive approach through the Selangor Syariah Justice Department (JAKES) on 1 May 2002. Its profound impact is highly evidenced in the 2022 statistic, where 98% of registered Sulh cases were successfully resolved within 19 days, thereby significantly boosting the overall credibility of Sharia. Next, we move to the research methodology. This article used is the qualitative methodology. First, document analysis. This qualitative case study analyzed physical Sharia court file from the 2020 to 2025 to evaluate compliance with Sulh agreement. The analysis focused on the complaint classification code related to the order violation, particularly committal and judgment debtor summon case. 2. Interview. Semi-structured interview were conducted with vast experienced enforcement, including Sharia judge and Sulh officer. The interview conducted practical insight into the challenge of the implementing and enforcing Sulh agreement. Funding and discussion. The true measure of a compliance. This study highlights that the true compliance with the Sulh agreement extends far beyond the mere signing of a document by the disputing parties, inherently required by the holistic implementation of the all agreed open term once they are officially endorsed as a court's order by the judge. Consequently, the actual effectiveness of the Sulh process is measured by the party genuine adherence to the order and the corresponding lack of violations cases filed in the court. Therefore, ultimate success relies not only reaching a initial agreement during the council, but the practice ability of the party fulfilling new responsiveness. Element of an effective agreement. This study identified 4 critical elements necessary for an effective Sulh agreement. First, the physical and mental readiness of the party. Second, strict alignment with the Islamic law to ensure validity. And the third, absolute voluntary consent without external pressure. And the last, practical feasibility based on the party actional capability. Sulh officer and Syariah court carry the heavy responsibility of reviewing and evaluating all them to ensure the legal sound clear, fair, and also actionable. Ultimately, this demonstrates that the true success of Sulh rests entirely on securing long-term compliance rather than just a temporary agreement.
Okay, next I will continue for the summary. The author also highlight the challenge to compliance with Sulh settlement agreements. Lack of commitment, cooperation, and communication are the main challenge in ensuring compliance with Sulh settlement agreements. After the consent order is endorsed by the courts, its implementation depends entirely on the parties because there is no continuous monitoring by the court. Poor communication, such as ignoring calls or messages regarding child visitation, may also lead to misunderstanding and breach of the agreed term. Next, the author also mentioned about the implication of breaching Sulh settlement agreements in this article. Breaching a Sulh consent order may lead to legal consequences and enforcement proceeding. When one party fails to comply with the agreed terms, the affected party has the right to file an application before the Syariah court for enforcement. As provided under the enactment Undang-Undang Keluarga Islam Negeri Selangor 2003, the court may take appropriate legal action against the defaulting party. This demonstrates that a Sulh settlement is not merely a mutual understanding but a legally binding court order. Okay, next we will move to the type of breach. This article highlights two main types of breach of Sulh consent order, namely judgment debtor summons and committal proceeding. The judgment debtor summons is illustrated through the case of Nurul Asilah binti Muhammad Asif versus Muhammad Asif bin Abdul Talib in 2023, which involves the respondent's failure to fulfill financial obligation under the Sulh settlement agreement. Meanwhile, committal proceedings are demonstrated in the case of Muhammad Sazlan bin Sirajuddin versus Si Lian Chan in 2023, which concern the respondent's non-compliance with child visitation order. The last part in this article is talking about recommendation. This article recommends several measures to strengthen the implementation of Sulh settlement agreements. These include involving authorized third party, introducing a reminder mechanism on the legal consequences of non-compliance, and enhancing the competency of Sulh officer through recognized mediation training to improve the effectiveness of the Sulh process.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Badal Amin bin Muhammad Rizwan. My metric number is 1231658. And now I want to talk about critical analysis, significant strengths of the article. For number 1, addresses a significant research gap. One of the article greatest strength is that focus on compliance with Sulh statement orders after the agreement has been endorsed by the court, rather than merely discussing of effectiveness of Sulh in resolving disputes. Most previous study emphasized success rate of Sulh, whereas this study examined this post-settlement enforcement phases, making it a valuable contribution to Syariah legal scholarship. For critical analysis, for number 2, significant strengths of the article, which is use an appropriate qualitative methodology. This research employ a qualitative case study using semi-structured interview with 5 experienced informants from the Selangor Syariah Judiciary Department and document analysis of actual court files from 2020 till 2024. This methodological of the findings because the conclusion. This methodological triangulation strengthen the credibility and trustworthiness of the finding because the conclusion are supported by multiple sources of evidence rather than relying on a single method. So lastly, for the significant strengths of the article, relies on experience and relevant information. The study interviewed key stakeholders including head of alternative dispute resolution, Sulh officer, a former Sulh officer and a Syariah court judge. This informant possesses extensive practical experience, providing authoritative insight into the implementation and enforcement of Sulh agreement. So that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Amira Nazra binti Amir Rashid. My metric number 1233200. For critical analysis, I will highlight 3 weaknesses of this article. The first weaknesses is regarding the scope and methodology of the study. The article states that the study only involved 300 respondents at the Syariah High Court of Selangor. However, the article does not explain how these 300 respondents were selected, whether randomly or purposefully. The article also does not state whether these 300 respondents represent all types of Sulh cases, such as maintenance, property division, or custody. Furthermore, the article only used a quantitative survey method. There were no in-depth interview or case file analysis. As a result, the article only stated that 14 respondents failed to comply due to financial problem, but does not elaborate on what those financial problems actually entail. Next, the second weaknesses is the article's lack of discussion on enforcement. The article mentioned that Sulh orders have the same force as a court judgment under Rule 79, but the article stopped there. The article does not explain what action was taken against the 14 respondents who failed to comply, whether they were subjected to a warrant of arrest or civil action. The article also does not address whether there is any monitoring mechanism after the order is issued. Therefore, the article's analysis is limited to statistics only, without assessing actual effectiveness on the ground. And the last one, the third weaknesses is that the article does not discuss qualitative factors. The article emphasized that Sulh is effective and cost-saving, citing Section 47 of the Administration of Islamic Religious Affairs, Selangor, Enactment 2003. However, the article does not discuss whether Sulh agreement were made voluntarily and fairly. The article also does not address the possibility of pressure or power imbalance between parties during the Sulh process. In addition, the article does not elaborate on the challenges faced by judge or registrar when handling complex cases in the Syariah High Court. This makes the article's portrayal of Sulh somewhat idealistic.
Reflection. This article made us realize that the true success of the Sulh process is not measured by hard settlement statistics, but by the level of assured voluntary compliance based on justice and trust. We also recognize that the heavy responsibility placed on Sulh officer, they must draft highly detailed and enforceable terms because vague agreement will be only complicate future enforcement. We fully support their authoritative measure like involving third party. We believe future study need to explore the perspective of the disputing party themselves, look into digital technology for the better monitoring. Ultimately, as law student, we learn that Sharia justice does not end with a judge decision in court, but it only truly achieves when that justice is realized and protected in society every day.
Okay, last part is conclusion. In conclusion, the article highlight the importance of complying with Sulh consent order to ensure the effectiveness of Sulh in the Malaysian Sharia Court. It demonstrates that the success of Sulh depends not only on reaching a settlement but also on the parties' commitment to fulfill the agreed terms. Overall, The article provides valuable recommendations to strengthen compliance and enhance the credibility of the Syariah court system. That's all from our group. Thank you for the attention.